Welcome to 5 at 5 with Stone Law. I'm attorney Brendan Bybee with 5 minutes on why, if you already have a trust, do you also need a will? Most people are getting a trust thinking that the trust replaces a will. So I'm using it instead of a will. And that's not entirely wrong. There's a lot of truth to that. But regardless of having a trust, regardless of the expectation that that trust is going to handle all of your estate planning needs in terms of who gets what of your property, we still always want to include a last will and testament. And it's part of ensuring that your plan works, that your plan is going to be carried out. And also because there are things that a will does that are not necessarily accomplished in the same way by a trust. Now, in the first place, when we're dealing with property, why might a trust not be sufficient by itself? Why would we still want to have a will? Well, you hopefully understand that a trust only governs the property that it owns. So in order for that trust to carry out its duty, its role in your estate plan to serve you and to serve your beneficiaries, it has to own the property. If it doesn't own that property at your death, then the property either has to get to the trust by a legal right through a beneficiary designation or a pay on death designation with a bank account that occurs at death, that essentially only needs a death certificate to be enacted and carried out, or it's going to have to go through a probate process. Now, in some cases, that probate process may not technically be probate. If it's small enough amount of assets, it may be transferable by an affidavit or otherwise not require a full probate. But if it's more than that, there's more property that you have, significant amount of property that you left outside of your trust at the time of your death, then it's going to have to go through a probate process. The probate court's going to say, okay, now the trust is the beneficiary of this, and then it's going to get transferred over. Obviously, we want to avoid that. The only way to avoid that is to make sure the property is already in your trust. But in too many cases, property is neglected to be transferred. In some cases, it's because they had real estate, they refinanced their home. When they did that, the bank made them transfer the house out of the trust into their names and then do the refi. And then afterwards, they were left to transfer it back into the trust themselves, and they never did. That happens way too often. Fortunately, with our clients, as we try to keep in touch with them and are able to schedule reviews periodically, then we can kind of follow up with them and say, have you transferred your house? Have you had a refinance? Anything like that that's changed title? We need to get it back into the trust. So that's one way that people might, who otherwise might be very conscientious about getting their property in the trust, might leave something significant out. Another thing that happens is that, again, people forget assets that they have. They maybe get stuck with the process being too complicated and they sort of give up on the transfer. They might have odd assets like, say they have stock certificates for an old stock, and now they don't really know how to convert that to something meaningful. They don't know how to change the ownership over. Those are things that can be dealt with if you talk to your attorney. We can help you, guide you through that, and in some cases take over that process for you to assist with that funding. But those are things that sometimes happen. Another thing that might happen is somebody might be gifted or inherit some property, perhaps even after they've lost their own capacity. And if their powers of attorney aren't quick and go and somebody under their power of attorney goes and moves that property and transfers over into their trust before they die, they may have property that's left outside of the trust and therefore has to be dealt with through a probate process. If you don't have a will that designates your trust as the beneficiary, then it's going to go through intestate succession. It's going to leave that property to individuals. It's not going to go to your trust without a will that says so. So again, it's important, regardless of why that property might be outside the trust, that your will says that it goes to the trust. So that, again, that's why we always want to have both of those things in place. Now, the other point is a will does things that a trust doesn't do. A will is not generally an effective document until your death, and that's true. But a couple other instances that they come into play is kind of important for that. And one of those is that you may, if you have young children, or even if you have adult disabled children or grandchildren who are dependent upon you, perhaps their parent died or otherwise is disqualified for parenthood, and therefore you ended up becoming guardian for grandchildren, perhaps. So when you pass away, obviously you will no longer be able to care for them, but a will is a document where we typically will name who is going to step into that role of guardian for those minor disabled children. And so again, we've got a trust that can take care of the property, but who's going to take care of, son or granddaughter who is disabled and dependent upon you, or is a minor and dependent upon you. And we typically don't want to leave that up to chance. We don't want family to be fighting over who's going to be taking care of the children and being in charge of their schooling and their general welfare. And it doesn't have to be the same person that's in the trust. It could be somebody else. But you really should want to be able to say who's going to take on that role. And that's what we typically will do in a will. And because the will becomes a document that we can file after your death that can state that intention, that's typically where we'll name it and where that can be helpful. Now, the final thing I'd say in terms of having a will that is very helpful will be in some rare cases where perhaps one spouse or the other will have a financial need due to healthcare problems that they have. So what I'm talking about here is there may be, because of advanced medical issues, a benefit to a surviving spouse being able to qualify for Medicaid. Now, if you have a trust and everything, the deceased spouse's property all goes to the surviving spouse through the trust, then they cannot, there's no way for that trust to be able to create a supplemental needs trust for that surviving spouse and provide, allow them to be able to qualify for Medicaid and still have the assistance of those trust assets. In those cases, our trusts direct the assets of the deceased spouse to be put into their estate. Now that does cause a probate, and normally that would be inadvisable. But in this case, under the federal statutes, the only way that the surviving spouse can have the deceased spouse's portion of the property held as a special needs trust for their care is if it goes through the estate. In that case, it can go, the trust will designate to go to the estate, pour through the will, and then create that special needs trust for the surviving spouse. And though that doesn't happen in many cases, maybe not most cases, it is one other reason why having that will in place so that that trust and the will can say, in this circumstance where a surviving spouse would benefit from a special needs trust, these work in concert together to put the property back into the estate where ordinarily we are avoiding that for the purpose of providing that benefit for the surviving spouse, making sure they can get the medical care that they need without having to be rendered entirely destitute, so that the surviving spouse's property can be used to improve their quality of life for the remainder of their lifetime. Now, those are just a few reasons, critical reasons why we always have a will, even though we have a trust. But again, we never want to rely on a pour-over will that pours property into the trust for our estate planning. So if you have a trust, make sure you move your property into it now while you can. And if you're having trouble, if you're struggling with that, or you just don't seem to get around to it in spite of all your good intentions, let us know. We can take on part of that role and get things lined up and move them into your trust so that it can function properly and you can avoid probate and your estate can run efficiently and be a blessing to your beneficiaries. If you have any questions, as always, please let us know at Stone Law Offices. Come in and see us and we'll help you get your estate in order.